and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law Section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners curious to hear what's top of the mind for the experts in these fields. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Trial Practice Committee of the Antitrust Law Section. Today's episode is on the delicate dance of joint defense groups. For those of us who come from a prosecution or plaintiff side background, joint defense groups can seem like a formidable wall, their wagon circle, their movements calculated. But inherent within these groups is a tension between their common goal of winning the case and their individual interests in case strategy, use of experts, and what is best for their own client. For all the things that bind them together, there are 1,000 little factors that can splinter their cohesion. As familiar as these institutions are to civil and criminal antitrust litigators, they're ones that we rarely talk about, and it's rarer still to pop open the watch face and see just how they work. Today, we're going to dive into the world of joint defense groups, what makes them work and the ways they can go wrong, and end with some practice guidance on how to make them work more smoothly. Joining me today as my co-host is Anna Pletcher, a vice chair of the Trial Practice Committee. Anna is a partner at the O'Melveny Law Firm. She joined the firm after many years as a trial attorney in the Department of Justice's Antitrust Division, which included serving as the assistant chief of the division's San Francisco office. Prior to that, she and I were college classmates. Recently, she was part of a 10-defendant joint defense group that went to trial 3 times on allegations of criminal price fixing in the chicken industry. Anna, as always, nice to see you.
Nice to see you too, Anant. Great to be here today.
Anna, who do we have on the show today?
So today we have 2 fabulous guests. We have David Cross, who's the chair of the Antitrust Litigation practice at Morrison and Foerster. And we have Dr. Laila Haider, who is an economist and vice president at Charles River Associates. David, can you tell our listeners today a bit about your background?
Hi, Anna. Thanks for having me on. I am a trial lawyer who focuses on antitrust litigation. I've defended numerous clients in a wide variety of antitrust matters, ranging from price fixing to monopoly cases, numerous class actions. I spent a lot of time in joint defense groups over the years, for better or for worse, and it's been quite the experience, and I'm looking forward to talking about it today. I like to think I'm a really good dancer or not. I've never found anyone else who agrees with that, so I'll share whatever insights I can on this delicate dance.
That's great. Laila, can you tell our listeners a bit about you?
Thank you very much for having me here today, Anant and Anna. It's a pleasure to be here and to speak with you. In terms of my background, I'm an economist and I regularly testify in antitrust cases. Over the course of my career, which has now spanned more than 20 years, I've worked with a number of joint defense groups. I have testified in a number of antitrust cases where I was jointly retained by the joint defense group to provide expert testimony. And earlier in my career, I worked with a number of joint defense groups and was often the lead economist who was handling the group with respect to the expert work. So I think it's fair to say that I have seen my fair share of different dynamics at play within different groups.
So Anna, let's start with a little frame setting for our audience on when you either choose to or have to be in a joint defense group.
Right. So antitrust cases in particular often involve multiple defendants. They're legally complex and typically very expensive to litigate. So defendants agree to work together in a joint defense group. They can share information, they can share strategies and resources too. So that can be a big advantage. And of course, there is a common interest privilege that protects joint defense group communications. So you often see different joint defense groups forming right away as soon as cases are filed.
And you can see these in criminal cases and civil cases.
Absolutely. You see them in both places for the reasons I just explained. There are a lot of advantages.
So what I found fascinating when the 4 of us were coming up with this podcast, as someone on the outside trying to pull the curtain back a little, is how different the dynamic seems to be versus representing a single client. You're like a band of equals working towards a common goal, but with your own client interests, different resources, different thoughts on strategy, et cetera. What are some of the unique challenges in joint defense work that are very different from being sole defense counsel?
So I would say the biggest challenge is decision-making, right? When you're on your own representing a client, it's your decision to make together with your client. When you're a joint defense, everything is by committee. And so now you find yourself having to persuade a lot of different types of people to agree with whatever it is you want to do, and you have them trying to persuade you and your client to go along with whatever strategy they have in mind. And, we tend to have a lot of type A personalities in the antitrust bar, or I'd probably say the legal profession in general, a lot of really smart people. Really smart people can have a lot of different views on strategy and tactics and day-to-day decision-making. And so that is the biggest challenge you run into is, how do you resolve differences, particularly when they're very sharp differences, and move the ball forward?
Typically what I've found is that the larger the group, the more variety there is in terms of the individual preferences of group members. And this is not surprising because, of course, the more parties there are, the more likely it is that members will be differently situated. And so what I've generally found is that the larger the group, the harder it is, just to follow on what David said, the harder it is for them to reach consensus quickly. So it usually takes some time. Smaller groups tend to be more nimble because they can work out their differences more easily. And this is one reason why when it's a large group, it often is very helpful when there are subcommittees formed to take on particular work streams or particular significant projects, which would also include dealing with an expert team, for example.
Right. So sometimes, and it's been my experience at least, that with all those cooks in the kitchen, that can slow down the pace of litigation sometimes. Have you all had that experience too?
And, when you're making decisions by committee, you're just not as nimble. And it takes a long time to make those decisions. And you run into disagreements on pace itself. My instinct often is to try to move things forward quickly and aggressively to put the plaintiffs to their proof and not give them lots of time to just go fishing for a case. There are other folks who have the very different view that the slower things move, the more delay there is, the better it is for their clients, particularly if there's a notion that the clients are going to pay something eventually, like in guilty plea cases where your focus might be more on damages than liability. And so it certainly does not move as quickly as you would if you were on your own and had control over your cases.
Let's talk about some other differences between individual and joint defense situations. David, were there some other thoughts that you had on this topic?
Yeah, one of the biggest challenges you run into, I think, in a joint defense group is one of the key factors is trust, right? So you're working with a lot of different people. You're sharing information that can be damaging for your client if it's shared outside of the confines of the privilege of that group. And so, building trust is important, maintaining that trust is important, and then you're all depending on each other because a single defendant can adversely affect everyone in the group. I had a case several years ago where a lot of folks were frustrated in the group as we got into depositions because one particular defendant's witnesses just, in our view, were not well prepared. They were getting questions that they just didn't seem ready to have answers for. And you would sit through these depositions one after another, and each of us, as politely as we could, would talk to their counsel and suggest ways that they could be better prepared, suggest ways that we might help. And it was just resistance. And, then you get into filings and that testimony is emphasized again and again against the entire group. And so you're only as strong as the weakest link in the group. And unfortunately, sometimes you have a weaker link that it's difficult to manage and protect your client's interests in that situation.
So one thing that surprised me during our prep, I just assumed that joint defense groups are sitting on the other side in complete transparency with their co-defendants. But I realize now that may not be the case.
Yeah, certainly you don't have complete visibility. Again, trust is a factor. And so one of the biggest decisions that we're making in a joint defense group day in and day out is what do we share? Some folks share more than others. And that's often part of the challenge is you don't know what you don't know when someone else may have really damaging evidence that you're not aware of and it doesn't get shared with you, particularly if it gets shared with the other side where you've got someone that's cooperating or they're trying to position themselves for settlement. And it actually happened in a case several years ago where we were in a very large joint defense group. The plaintiffs kept telling a bunch of us in settlement talks that they had, in their words, smoking gun evidence of collusion. We thought it was posturing. And when one of the defendants finally announced they were settlement and leaving the group, we discovered at that point that they had shared damaging evidence that they had in their files about some of the folks in the defense group with the plaintiffs. There's nothing unethical about that. It was their own confidential information, but we didn't know that. And so, the transparency becomes a problem. We like to think that everyone's sharing and cooperating, and I think people do to a reasonable degree for the most part, but you are trying to protect your own client's interest. And that's where you can kind of get at odds every once in a while, and you find yourself wondering, What does the other side maybe know that we don't?
All right. So a little more on just understanding the structure of these joint defense groups. How large are they?
So joint defense groups can vary in size. I have worked on matters where there may be 2 defendants, and I've also worked on matters where there may be up to 20 defendants. And so if you factor in at least 5 or more attorneys per defendant, you can see that some of these groups can become very large.
Yeah, but especially when you get to the larger groups, how do you split up costs and figure out how to share resources?
One of the most common ways is just pro rata, right? So the bigger companies by revenue tend to pay more. It's not always that way. Sometimes we'll just do it equally. But I'd say that's probably the most common way, is to try to figure out a fair way to do it, right? So if you've got a really small company by revenue, particularly in a cartel case, a really big one, we'll figure out some fair, equitable distribution. One of the challenges you run into on the paying side is sometimes you have members who don't want to contribute at all. Sometimes they just can't afford it. I mean, some of the cartel cases, very small companies will get sued. They're not accustomed to litigation. They don't have in-house counsel. They just don't have the resources. And so you're always sort of balancing, what's best for the group, because everybody needs the help of outside vendors in a variety of ways, including experts, trial graphics, trial consultants. But you got to avoid the free rider situation. And so, if it's a situation where someone clearly they just don't have the resources, the larger folks tend to accommodate that. If it's someone who does and they just want a free ride, that's a different discussion. But we find ways to work it out.
The same is true for individual defendants, too, where some have more resources than others. Some may be directors or executives who are covered by their company. Some of them are not. So that's an issue also when you're dealing with individual defendants in a joint defense group.
As David said, of course, the lawyers work on, how they will divide costs for, say, expert work. And then that is typically communicated to the expert team. I have seen and worked on cases where groups will decide to share all the expert costs. And by that, I mean costs for data processing, costs for economic analysis, costs for the preparation of the expert report, deposition testimony, trial testimony, all aspects of it. They'll share it based on, whatever shares they've come up with. I've also worked on cases where the decision from the group was to not share the data processing and data cleaning costs, such that each individual defendant will incur those costs, and then they'll share some of the other aspects that I described, such as preparation of the expert report and conducting economic analysis and so forth. And I think in those scenarios where I've seen and I've worked on these cases where the defendants have sort of individually borne the cost of their data preparation, it's often because the data may vary substantially in scope. It can also be because there are some big differences in terms of size. It's the size of the different defendants that are involved. And you see a variety of different situations. I've also seen groups share costs equally. So you see a range of different scenarios.
So let's shift gears for a minute and talk about leadership. Leadership can be a really dicey issue when you've got a big group of people, as David said, a lot of type A personalities, right? Who's going to actually lead the ship? So in plaintiff side cases, right, they're appointed by a judge, but with a joint defense group, it's a whole different ballgame. And, the antitrust bar in particular, it's very small. You're working with repeat players. Referrals and future work can come from these folks. But at the end of the day, somebody's got to take the leadership role. So let's talk about how that gets worked out. David, what are your thoughts?
I'd say sometimes I think it'd be best if the court did on the defense side what they do on the plaintiff side, where they actually pick people and we all put in our submissions. But I don't think our clients would like that. And so I would say it generally works as a meritocracy, right? The folks who have the most relevant experience, the best contributions, they build trust, they build rapport, they tend to rise to the top, and it works quite well. The most important ways for me are being vocal early and often in ways that folks find helpful, shouldering a lot of the work so you're not seen as a free rider, making yourself available to participate in important discussions and drive strategic thinking. And then again, those leadership roles will kind of cement over time.
So there's leadership for the larger group as a whole, but then there are a lot of different tasks that have to get done in any large litigation, right? So there's leadership of smaller and different pieces, right? So somebody's got to lead, for example, the expert piece of litigation. Laila, how have you seen that work from your perspective?
When there are large groups, it's typical that the groups know to form what we'll call a subcommittee to deal with the experts. That subcommittee will have fewer lawyers on it, and they'll sort of be chosen by the group to deal with the expert. In smaller groups, it may be that there is one particular firm that are dealing with the expert, and so there are some winning characteristics that I think these individuals who take the lead do possess, in my experience. And so ideally, you want to, as in a group, you want to pick someone who is comfortable with and hopefully enjoys working with the expert economist team. So this person is someone who will take in ideas, take in suggestions in terms of what work needs to be done when, and then take it back to the group for further vetting. And so it helps if this person has a good understanding of the economic arguments at play, has good instincts in terms of figuring out, what's helpful to do now or later. And also, I think it helps when the person has really good rapport with the expert team. Second aspect of it, which is actually pretty significant, as you will know doing this work, is there's a pretty significant herding cats component to managing joint defense work. And so what I found is that when the person who's taking the lead is someone who's very organized, engaged, focused, extremely communicative, and is also really able to hold people in the group accountable for things that they were supposed to do. So let's say that the different members are supposed to provide certain documents or certain data to the expert team by particular dates. It's very helpful when that lead person that the joint defense group has appointed is able to, really try to do their best to hold their joint defense colleagues accountable.
And, this whole subcommittee structure was fascinating to me as someone who's not on the defense side. And it's not just a subcommittee to deal with the experts, but from what I understand, if you have a subset of defendants who have an issue that the larger group doesn't, you have a subcommittee for that. It's like within this joint defense group, it's a giant HOA structure.
Absolutely. And different legal teams may have different strengths even within that. Like there may be a team that's particularly good writers, for example, and they may take on more of the burden of the briefing. So everybody kind of sorts out, ideally, into ways where their strengths are maximized. And that way you can kind of maximize the group's potential. Okay, so let's get into the real tell-all, spill the juicy details moment right now. Starting with you, David, what are some of the thorniest issues that can come up with joint defense groups? Because we know they happen.
The thorniest is just working with other people, with a lot of lawyers, again, who are all really smart, come from different backgrounds, have lots of different ideas and thoughts. And, we talked about the leadership and how it tends to be a meritocracy. It's not always that way, right? Sometimes you have somebody in your joint defense group who's very vocal, very strong-willed, has lots of ideas, pushes them really hard, and everyone else in the group kind of has their head in their hands saying, how do we deal with this? Because as a group, we don't think that's the way to go. And they want to lead things, and folks aren't really looking to them to lead. And that becomes really challenging to deal with when it comes down to how we execute, right? What motions are we filing? What defenses are we asserting? How are we preparing witnesses? What do we want to say to the judge at any given point in time? And, what's our fear that someone's going to go it alone and stand up and say something that the rest of us just find affirmatively unhelpful? And that can be really difficult to control sometimes, particularly in fairness to some of these people. They've got a client behind them, right? And their client's telling them, I want you to do this. And, we've had moments, I can remember one case in particular where one of the defendants had a very difficult in-house lawyer who was very strongly viewed on aspects of the case. And, we developed a good enough rapport and relationship and trust over time with their outside counsel that their counsel would be honest with us to say, look, I don't disagree with you, but I've got a directive from a client and I'm going to have to stand up and do this, or I'm going to have to file this. And you feel bad for those folks because they're in a tough situation. And so we find ways, obviously, to make that work. We talked about sharing information. Again, that's one of the thornier issues. I mentioned before the situation where folks were sharing stuff and the rest of us didn't know. And when you find about that later, particularly if it happens and they're still in the joint defense group, that undermines trust and then makes it difficult to move forward with those folks. I ran into that myself years ago in a very large joint defense group at a prior firm. I was representing one of the largest defendants. Woke up in the morning with frantic emails and voicemails from my client who was upset because he had gotten a letter threatening to sue them in the very same litigation where we were representing them as a defendant. Then I start checking more emails, and I have similar frantic emails from others in the joint defense group whose clients had gotten the same letter threatening to sue them in the same litigation where we were representing the defendant. And lo and behold, the letter was sent by one of my partners. So talk about a nightmare scenario that came to life. We spent a period of days and weeks frantically fixing that. Leadership, to their credit, stepped in and we got it resolved. But, we were immediately kicked out of the joint defense group. We were dropped from all communications. The client lost trust and faith for a little while, to the point that folks were talking about a bar complaint. I had to hire ethics counsel. And in the end, it's one of the reasons I end up where I am today, moving my entire team to protect the client.
Wow. Yeah, that's a good example of how things can go very wrong. But there's so many moving pieces and so many different considerations when you bring all these people together in a joint defense group. And that sounds like a perfect storm. Let's talk a bit about how joint defense groups work from an expert perspective, because in an antitrust case, it's not an antitrust case without a whole team of experts, right? So this is something that everyone in the antitrust bar deals with. Laila, can you talk about how to work with a joint defense group from the expert perspective? It can't be easy.
So I think one of the most important ingredients to make the relationship a good one is clear and consistent communication so that there is transparency. I think that is extremely helpful to do that from the get-go in order to get trust from the different members. Some of the things that David has already touched on. So you want to set that up from the beginning. And groups will know that the way to do this is to have regular calls set up, to have, a great deal of communication between the expert team and the joint defense group. And then, of course, issues will come up related to pace and a number of other issues, which, I'm happy to describe. But I think in general, what I found is that good communication is the way to resolve a lot of issues that do arise.
So we had talked a bit about how sometimes there's just one team that's in charge of of lawyers that's in charge of working with the economist, but that means maybe that others in the joint defense group don't have full visibility into what's happening in terms of developing the case on the economics side. Have you found that to be an issue, and how do you deal with that?
Yes. So speaking of, thorny issues, so one issue that does come up is that when the group is large, invariably there will be, some people in the group who may feel that they don't know enough about what the expert team is working on. They don't know enough about the why the priorities were what they were, and then they may feel at the same time that they are incurring costs, and it can be worse. They can also say, we never authorize this particular work to be done, and therefore that causes tension, of course, within the group, and it slows things down, and so the way that I think a way around that is, of course, to which we have done in cases is that you provide just very short updates. This could be, by email, just very, very short, easy to digest ones that will go to everybody, not just, they may go through the subcommittee or they just go to everyone in the joint defense group, and where the team will say, here's what they've worked on, here's the progress that was made, or here are the different projects that they were authorized to do, and where they are on those projects. And I think that goes a long way to try to avoid some of these issues from coming up.
Sometimes individual defendants within the joint defense group will prefer to hire their own expert, in which case you'll have multiple different experts. In the chicken case, we had multiple individual defendants who hired their own experts, but only one ended up testifying at trial. And it took some work to get everybody on board and confident in that one expert. So what we ended up doing was we had that expert testify in a mock setting in front of the whole joint defense group to see how everybody felt about the expert and make sure that everyone had the right trust and everyone was on board. But Laila, in a scenario like that, where there are multiple experts, how do you end up not stepping all over each other's feet?
Yes, so this is also something that joint defense groups grapple with, because, as you say, it's very common for there to be industry experts, individual experts for the defendants, joint experts. Could be, then of course, class certification experts, multiple merits experts. So this happens often. I've been involved in cases where I've testified as the joint expert, but then there were a number of individual experts that were testifying on behalf of individual defendants. So the way to deal with this so that people are not stepping over each other, and also if it's not just a matter of, if it's not even just about stepping over one another, also just to avoid teams doing overlapping work, because then of course that can be inefficient and costly for the client. The way to, of course, deal with it is that the joint defense group, working closely with the different expert teams, has to make sure it's very clear what the particular assignments are. Even if there is some work that would need to be done that's overlapping across the different teams, typically, when groups are really thoughtful and mindful about this, they'll make sure that they get from each of the expert teams what the proposed projects are that they want to work on, but then they will have very clear instructions or very clearly delineated tasks across the different teams so as to avoid overlap.
But it's not just overlap too, right? Because there's also an issue of joint work versus individual defendant-specific work. And how do you, on the expert side, clarify that? Or what is your process when you have to balance those?
So, of course, you can imagine that there are economic questions that are specific to individual defendants. And then there are questions that the joint expert will be taking on. When individual defendants have their own experts, they will usually have their own experts deal with particular individual or defendant-specific issues. Having said that, because you're working with a joint expert, and it may be that, say, the team that I'm working with, we have prepared the data and we have a great deal of information. It is not unusual when you're doing joint work that there will be questions from individual defendants that go to the expert team of the joint expert, where they might want to know things like, who were our top customers, which products did we sell to those customers, what were our sales during different periods of time. This may very well even be just for settlement purposes. And so usually what joint defense groups do is they will know that some of these individual inquiries will come up, and it's very helpful. They've sort of set it up from the beginning that when there are these individual questions, the attorneys can go to the joint expert team who have the data and have all this information handy to provide that information. And that's not something that will sort of undercut the trust that somehow the joint expert team is working for individual clients. It's more that there's some individual assignments that are more descriptive that can be done. And then when it comes to this bigger question of, are there economic arguments that should be pushed through an individual expert, that's where there is a very clear delineation, and there will be a separate expert that will deal with those issues, because they may very well not be aligned with another defendant.
And if I could, one thing I would add One of the challenges we face in joint defense groups is not just how we handle our own experts across the group, whether it's group or individual, but how we handle the other side's experts. I had a case several years ago where we had this bizarre outreach from someone to one of the joint defense group lawyers who said that the lead class expert on the other side for the plaintiffs had been advising a company that was buying class claims in that litigation. It was such an outlandish report that virtually everybody in the joint defense group dismissed it. Our team and a couple of others thought, well, we should at least look into this. A lot of discussion, resistance to wasting time on it. We decided to go forward. We deposed the expert on it. He denied it. And then we decided just to serve a subpoena on this organization. And boy, it was crazy. We got documents showing that he had invested, this is all public, he had invested $1 million of his own money. This is the class expert on the other side, in a fund that was buying class claims in our current case. They produced documents indicating that he was advising them on confidential information based on our review of the documents. And he had a huge bias, was our argument, right, to get a class certified because those claims are worth the money he's invested only if those claims exist, which means he has to win on class cert.
Well, in some ways, that's a great example, David, of one of the traps that can happen in a joint defense group, which is the groupthink concept, right? Where a lot of people kind of glom onto this certain idea and the train starts running, and it's really hard to stop it if you think the group needs to go in a different direction. And sometimes that means that an individual group might go off and do what you did, right? That extra investigation that yields something really important. But resisting that groupthink can be a really important and challenging piece of being part of the joint defense group.
Yeah, I completely agree with that. Going it alone, I think most of us try to view as the nuclear option, unless it's a way that's not hurting anyone, right? In that particular situation, we saw discovery. If it turns up nothing, it turns up nothing. Sometimes going it alone means someone decides to follow a motion that everybody thinks is affirmatively unhelpful, and that's the situation. Ideally, you would avoid, but run into it in a lot of joint defense groups. Sometimes it's benign, and there have been situations where it went sideways as we predicted, and it's hard not in those moments to say, hey, we told you so. Nobody wants to be that guy.
So let's go back to this topic of things that can go wrong, right? This is there's just so many options for the train wreck situation in joint defense groups. And we'll also talk about how we can make these things better. But some of these challenges are just really difficult. David, you talked about trust being breached. What other thoughts do you have about things that can go wrong in these joint defense groups?
I would say the biggest driver of when things tend to go sideways comes from ego. Sometimes the folks who are the most vocal in a joint defense group are ones who probably should spend more time listening. A lot of times in these groups, you'll have people who are truly brilliant antitrust lawyers. They understand the antitrust laws inside and out. They understand the economics inside and out, but they don't have a lot of trial experience. And again, like I mentioned before, what resonates in a courtroom, and not just with juries, but with judges. I think a lot of times we forget that judges are human. And what resonates with them may not be the same of what resonates in a classroom.
Yeah, I've seen that come to play too in the trial setting, where a witness gives a great admission, and then a co-defense counsel will get up there and do a cross-examination that undoes that great testimony you just got. I know that can happen in the deposition setting too. And maybe that comes from some of that kind of ego piece you were talking about, David. Laila, have you had situations like that?
I have certainly seen this play out in deposition where I've been in the room, it's a deposition of an opposing expert, and the expert has given very good testimony that's helpful to one side. And then because another member of the joint defense group presses further on that issue when it's their turn to ask questions, the expert gets a chance to sort of undo their answer. So it does happen.
And I wonder whether part of this is how these joint defense groups are sometimes just thrown together for a relatively short amount of time. I know these cases can also go very long, but if you have a team that's planning to work together or all at the same firm for a very long time, people kind of find their roles, right? But here you have these partners who are all thrown together, and this trust issue, I think, becomes more important at the outset because you may not even have time for everyone to kind of find their rhythm with each other, which is why this sort of vetting, this trust becomes more important at the outset than trying to figure it out as you go along.
It's a really good point, Anant. I would say, joint defense groups are kind of like an arranged marriage, right? You didn't pick this, right? Your clients all ended up in a case together. They didn't pick that. They went out and hired their lawyers individually, and suddenly everybody's thrown into a group and said, make it work for the benefit of everyone as a whole. Particularly when you have judges that move these cases really fast, you're scrambling to kind of figure out who's doing what decisions you're making. You're making strategic decisions in real time. One of the challenges you run into is when clients don't get along. And that's not uncommon, right? I mean, in cartel cases, you've got companies that are fierce competitors, contrary to what the plaintiff side might think, and they don't get along well. And so you don't have a situation where the clients themselves are cohesive and their in-house counsel may be talking in ways that are at odds with each other. And then suddenly the lawyers on the outside are kind of caught in the middle of that. And it becomes difficult to have an effective defense across the board or individually.
On that point, David, and there are situations, right, where the evidence is stronger against some defendants than others. Right, but in a joint defense group, right, that can create some tension where you have some who feel like the case against them isn't so good and they may be more kind of confident, whereas others have worse evidence. How do you handle that situation?
Oh, we throw those people under the bus immediately. No, I'm kidding. Again, everybody works as a group, right? You're all trying to trust each other. You're all trying to represent each other together. I will say, I've been in those situations where as the evidence unfolds, you get into your own fact investigation and folks start to share, you say, okay, our client here, we think really did nothing wrong, or maybe at least on a measure, they are way behind these other folks in the group. And one of the things you tend to tell your client in that situation, we've been there, is see if you can settle early and quickly, because this other defendant or multiple defendants, they're going to drag you down. One thing plaintiffs are really good at is taking the evidence or admissions from one defendant and sort of sweeping it across the board for all of us. And so you kind of sink or swim sometimes based on the worst evidence that comes to light from a single defendant. And so when one looks a lot guiltier than another, sometimes getting out early if you can is better. Even if you absolutely did nothing wrong, which is a frustrating aspect of these defense cases, is you have clients that say, I don't want to pay anything. And sometimes it just becomes a business decision on, maybe it's better for me to pay some amount now. I buy certainty. I don't admit any wrongdoing, and I'm lumped in with someone else who actually did something wrong.
In antitrust conspiracy cases, like the nature of the case, because it's a conspiracy, right, it's alleging that there was collusion among a group of people. So evidence against one defendant likely does hit everyone else. So the whole group, right, might often rise or fall together. A joint mock trial could be helpful in situations like that to understand how that dynamic will play in front of a jury. You do have to have trust in your joint defense group and your co-counsel to do a mock trial like that. So that's one way you could potentially address some of those issues.
Oh, on this trust issue, does that undermine the cohesion of the joint defense group if during the course of it you're thinking, hey, I got a feeling that this one client is working out their own deal? Or do you just kind of build that in, that you just know going in that, hey, we have this collective interest, but everyone's going to be looking out for themselves?
I've had one joint defense group in particular years ago where there was sort of a sense among all of us that there was one defendant who was very likely aggressively negotiating settlement. They just weren't that active. It seemed like they probably would be the one to settle. And so there was always kind of this concern about how much do we share with that particular defendant. And so what happens is, we talked earlier about sort of subgroups and subcommittees. That one just sort of organically developed kind of a subgroup among a smaller set of us where we would talk a lot ourselves, and we were exchanging more information and having more robust discussions on strategy and tactics that didn't include that and a couple of others, because there were folks in our group that we really trusted and worked closely with. So
And so the reverse of that, if you feel like, your client is in a better situation than the other defendants, can you try to cut a separate deal? What are the mechanics and considerations? How do you do that?
That's not uncommon, right? I mean, that sort of the tension that's built into a joint defense group is everyone's trying to act in the best interest of the whole, but you do have to look out for the interests of your own client. And if that means getting out early and entering into a cooperation agreement, for example, which is really common in these cartel cases, then that's what you're going to do, and that's what your client is going to decide to do. The main thing is that no one's going to breach the confidence, right? That something that's shared in confidence in the group is not going to get shared with plaintiffs. That, of course, would be a bridge too far. But making your own decisions in the best interest of your client where you're not violating confidences, we expect it, and we find ways to manage it. Things like a judgment sharing agreement, for example, there are pros and cons to that. The idea being if one defendant settles, they have to pull all of their commerce out of the case so that the remaining defendants have no joint and several exposure for the commerce that came out for the defendant that settled. There are devices that we as a group can come up with to kind of manage that tension.
One of the issues that does come up in groups is that there will be, you'll sense from early on that there will be some disagreements in terms of the extent of work and the timing of the expert work that should be done, say, earlier on in the case versus later. And I've been involved in cases where some group members were really eager to get economic analysis, up and running, while there were others that I think were not so willing. And so as a result, there are often, mixed messages from the group to the expert team. And it also ends up creating, I think, some tension within the group. And I remember in this one particular case, this was a case involving 3 defendants, when one or two of them settled. And that was, I think, probably one of the reasons why it was taking a bit of time to get going. Once they settled, then it became, much easier to control for the remaining group members to control the pace and get economic analysis done to fill the appetite that they had. And then some settlements do help groups because then they're more aligned in terms of where they're headed.
Well, let's ask our guests what their key takeaways are, and let's have them focus on the positive. We talked about a lot of the challenges in joint defense groups, but what are your takeaways for how to make them work really well? Let's start with you, David.
I would say the first takeaway, and it might seem obvious, reduce your joint defense to writing, a joint defense agreement. It lets everyone get aligned on what's the scope of our arrangement here, right? What's within the scope of our joint defense, what isn't. The second takeaway I would say is humility is just so important. Again, we've talked about egos. Being vocal is important. You're there to represent your client. You need to actively do that. But listening is just so key, right? In a joint defense group, you've got some of the most brilliant minds in the bar who bring a lot of different experiences and insights and ideas. If you are talking in these meetings a lot more than anyone else, I would say you're probably doing it wrong. You need to listen more because you're just going to absorb a lot and learn a lot. And it serves your client, right? I mean, one of kind of the inadvertent benefits of this is your client hires one firm, but they get the benefit for free of having a handful or dozens of other brilliant lawyers who get to offer advice. The third thing I would say along the same lines is be a team player. And that's not just humility and listening, but it's also contributing. Don't sort of fall into the free rider mentality. Find ways to contribute within the resources of your client, within your own skill set. And then I would say, again, along the listening piece, the fourth takeaway, I think sometimes there's a mistake that we should listen to the most senior people, right? The folks who've been doing this for 30 or 40 years. And certainly they have a lot of insight to offer, but sometimes the more junior folks have really creative ideas, right? They're earlier in their careers. They're not in the box that the rest of us have developed and kind of practiced in for so long. And so getting that outside of the box thinking can be really helpful to the group and to individual clients. And then along the same lines, the last takeaway I would emphasize is sharing opportunities, right? You're in a group. No one should be hoarding the opportunities. I don't think that serves the group well. It doesn't serve the clients well. In the antitrust world, particularly in cartel cases, class actions, these cases sometimes go 5 or 10 years. I remember starting my career early on the DRAM litigation went a really long time. Audit parts went a long time. We were in that. And so you've got folks who may be a first-year partner when you start, and by the time you're going to trial or even arguing class cert, they might be 5 to 10 years deeper into their practice. And the more opportunities you can find for those folks, whether it's taking key roles in hearings and depositions and just having a vocal seat at the table, is really critically important. It serves the group, it serves your client, makes for a good dynamic. And it's a small bar. The better we work together, the better it is for everyone.
Thanks, David. Laila, what are your takeaways for how joint defense groups can work well?
So I'll speak from the perspective of working well with expert teams. So there are several takeaways. I think some we touched on, but I'll enumerate them. So I think large joint defense groups should think hard about designating the best and most suited individuals on subcommittees to deal with the expert team, to have very clear structures set up for transparency and effective communication between the expert team and the lawyers. When there are multiple expert teams involved, I think it's really important that the joint defense group really thoughtfully thinks about division of labor, but gets input from the expert teams so that they can then clearly delineate the different responsibilities. There are obviously several best practices for expert teams as well who work with joint defense groups. They should provide regular updates, be extremely responsive, not do work that the subcommittee has not explicitly authorized them to do. I've seen, this was colleagues working on a case several years ago where the joint defense group had come up with a mechanism to avoid this issue of, whether certain work was authorized or not, or if everybody on the joint defense group understood that certain work was authorized to be done by the team. And the mechanism that they'd put in place was to say that it'll be announced what work stream will be conducted. And then the attorneys had 5 days to object if they did not want that work to be done. And if they did not object, and I think it was 5 days, but let's say some number of days. And if they did not object in that time, then the work stream was authorized. So this prevents some of the tensions we talked about earlier, where some members really want to get a lot of work done while others might be dragging their feet. And then I also think with respect to engaging the expert team on pros and cons of doing certain work sooner rather than later, the better it is. And so in general, I think in keeping with what David said, this is a long-term relationship because litigation takes many, many years. And so a little bit of patience and grace from everyone, but really, most of all, I think really good communication can take us a long way.
One other takeaway that I would offer is if you want to be active in the joint defense group and you want to have certain opportunities, dig in, right? Invest your own time, your own energy, do the hard work, particularly the work that folks may not want to do. One of the challenges we often run into is this idea where you have folks who kind of view themselves as the elder statesman. They want to pop into meetings and they offer all sorts of strategic ideas, but they are oftentimes, in their own words, unconstrained by the facts. And it's just not particularly helpful when folks are saying we should do all sorts of things and it's taking in directions the facts don't allow. Or sometimes you have folks that are like, I want to handle the oral argument on a dispositive motion, or I want to be, take a big role at trial. But they've kind of been absent when it comes to the hard work of taking and defending depositions, prepping witnesses, working on motions, working with experts on reports. And so, my view is earn those opportunities. And, early in my career, the folks that I looked up to and saw mentors did that, right? They were senior partners late in their careers where they could have played that role, but they were actively digging in. They were doing the hard work, staying up late, working weekends, and earning the respect of the group and earning those opportunities, because it really should not come as a given to anyone, no matter where you are in your career.
David, that reminds me of the person on the team who's always willing to flag things for other people to deal with. But listen, everyone, these were great takeaways. Thank you so much, Anna, David, and Laila, for this really fascinating glimpse into the world of joint defense groups. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.